let's see here, guys. Give me a minute. Let me get this working. Get the chat up. There we go. Oh dear. Let me see if I can. Sorry, I'm just updating the titles if it'll let me. Let's see if it'll let me do that. All right, hopefully that worked. And let's see if I can get this over here to work. Sorry, guys, I'm still getting used to a kind of new system here. Well, we're going to call that for the moment. All right. So, hi. How y'all doing? Okay. So, still trying out my new chatting and streaming system here. I've been looking today. So there's been something that I've been working on, researching for quite some time now, and it's caused me a great deal of frustration and anger and yelling and throwing of a couple of things. And I've lost my glasses. And I was particularly annoyed because, oh, there we go. As I got cited in this case the other day, and I was like, I know that can't be right. I know it can't be right because it's something that I've been researching, but then I went looking for it and I couldn't find it, and I looked everywhere. So I did finally find it, and I've been looking through it today and really getting on my nerves. It didn't say exactly what I remembered it saying, so of course that just made me madder. But never does, right? But I was going to, I need to go through it some more, and so I decided to just bring it here. And so you and I are going to do it together. Of course, I'm buried in paper, so I got to figure out what I did with what I really need. I brought everything over here, except the thing that I need the most. So give me 1 second, let me figure out where I stuck it. In an attempt. So essentially what we're looking at is going to be an 1848 case. Don't worry, I'm here. I'm just looking for the case. That was cited in this Portland case. And it's one that I've read a number of times, and I put a lot of stock in, but it's hard to read because it's from 1948. There's so much paper around here, you guys. The last like 48 hours, or 24 to 48 hours, have been a little intense. That case that came out of Portland took me by surprise a little bit. Sort of the strength of the opinion, and I don't know, just the way it was written really took me by surprise, and then of course threw me down a bunch of rabbit holes, because then I was like, wait, this doesn't seem right, this doesn't seem right, this doesn't seem right. But then I had to go research everything and find out if I was correct or not. And sometimes I was, sometimes I wasn't. But in order for me to respond to you guys, I needed answers. And so I started reading. And I read and read and read. And if you guys noticed, yesterday I came up with one answer, and then a little while later I realized I was wrong. Hi, Dylan. And hey, do it for Dale. And I, realized that I was wrong, which meant I had to write or, put out an apology video, which I haven't had to do a lot. But always hurts. It always stings a little. And it turned out, actually, that I wasn't even totally wrong. It was... You guys, I have been looking everywhere for this thing, and it's just sitting right here under the binder. So, it turned out I wasn't even really wrong. It was just written in such a weird way that it was hard to kind of parse what it was trying to say. Dayton, Ohio, awesome. I'm from Cincinnati, so right up the street, right down the street. But you know, there were just so many things in here that I kind of got lost. I have a tendency to get what's the word? Forest for the trees. You know what I mean? And so I'll get snagged up on a little detail. Yeah, well, I wasn't that wrong. Because what I said the first time is that they had given the right, they'd given the right to deploy. They'd allowed the president to deploy. And then I reread it, and it said that second TRO was still in place. And I was like, oh, well, if the second TRO is still in place, then he can't deploy. So I went in and I made that apology video because I was like, oh, I missed that somehow. And then, oh, Patchy Beard, unfortunately, trimming it does not make it look better. That's just genetics. This is just the way I'm built, unfortunately. Yeah, it was a frustrating evening, but a lot of reading, very little sleep, and here we are. So now what we're looking at, now that I found it, is Luther v. Borden. Luther v. Borden is a case from 1846, I think, 1849, and it's an interesting case because Northern Kentucky, awesome. That's where my mom lives in Covington now. It was kind of an interesting situation. So hey, Betharoni, there were, well, you know, I'm going to go through the fast version of the story here, God forbid. There were, when all of the new states joined the Union, they all kind of went through and wrote a new, playing The Sims, awesome. They all kind of went through and wrote new constitutions, right? But one state that didn't was Rhode Island. Rhode Island stuck with their 16 whatever charter. And the thing about that charter was that it had very restrictive voting rights. It only allowed a few people, thank you, Justin, only allowed a few people to vote. And what that ended up doing, from a practical standpoint, was keeping kind of the group of people who was in charge very narrowed. It was a very small group of people who was in charge, and they stayed in charge for a long time. And the rest of the people in the state started to get a little unhappy about that. You know, they wanted a shot. And there was no practical way. I mean, this was like gerrymandering on, I don't want to say the roids word here, I think that might grab something, but what ended up happening is this group of people essentially rewrote the Constitution and kind of created their own committee to approve it, and just said, we hereby decide that this is the new Constitution, these are the new rules, and we put in place a new governor and a new government of Rhode Island. And from now on, this is the government of Rhode Island. And so what you had for a brief moment were two governments of Rhode Island. Now, obviously, one had been in place, one had sort of put itself in place. And from a historical standpoint, it's very easy to see how one seems legitimate and one does not. I would imagine if you were one of those people who'd put the new one in place, you might think that the one that had been there from before was illegitimate. So there's probably a lot of opinions on which one's legitimate, which one's not. But eventually, this is going to come to the Supreme Court, and the Supreme Court's going to have to make some decisions about this. And we get some case law out of this decision that really has a big impact on a lot of stuff to this day. But I want to walk you through how we get there, because what happens is this guy Luther, and there's some names here that get very confusing, and so I'm going to try not to get into it too much, because like there's one guy named Luther M. Borden, which is Luther Martin Borden, and then I think the guy who arrests him is named Martin Luther Borden or something. Like it's very confusing. They have all almost the same name. I'm guessing they're all Lutherans. I'm talking about Luther v. Borden, and so he's sitting at home, and he's one of the guys who was in charge of kind of overthrowing or creating this second Rhode Island government. And these officials, like police officers or whatever, are sent into his house to arrest him. And he charges or claims that by doing that, by coming into his house to arrest him, they trespassed because they had no legal authority to enter his house. They weren't the government anymore or whatever. And so he files a suit for trespass for these police officers coming in to arrest him. He says it was trespass. And so that's what starts this whole case. So one of the kind of weird things about this is that it all revolves around this question of whether or not they trespassed when they entered his house, which makes the whole thing even a little bit more confusing. But the real big questions that we care about from this case are these. First, the Supreme Court gets asked which government is legitimate, because each of them has sent somebody to Congress. And actually, I don't think they end up actually sending somebody to Congress, but the question comes forward anyway. And there is this part of the U.S. Constitution, it's Article 4, Section 4, the Guarantee Clause, I think, is what it's for, Article 4, Section 4. And it guarantees, I'll make sure I read it right. Article 4, Section 4, the United States shall guarantee every state in the Union a republican form of government. And so one side of this argument, one side of this group of people says, hey, we are guaranteed a republican form of government. And that means we're supposed to have, a democracy. We're supposed to be, all represented. We're supposed to get all listened to, whatever. And so the Supreme Court needs to intervene and make sure that we are given that republican form of government. And so they should listen to the side that came, that elected from the broader group of people or whatever. And the other side says, we're the legitimate people. We were the ones that came from the old Constitution. We'd been here longer, whatever. And the Supreme Court looks at this and says, I don't think this is our problem. I don't think we're supposed to answer this. And the way that they sort of slither out of answering this question, frankly, is by saying, Congress under Article 1, right, or Article 2, whatever, is given the right to seat its own members. Congress is the one who decides the legitimacy of the members of its own house. So the House of Representatives, they get to decide whether the people who come into the House were properly elected or not. They're the ones who decide for themselves. And therefore, at the end of the day, they're the ones who are supposed to decide whether elected person number 1 or elected person number 2 is actually the correct person, the correct representative for this part of Rhode Island. This is not our decision to make as a judiciary. This is Congress's decision to make. And they start going through these different scenarios where they might be asked, to decide whether or not something is a Republican form of government or not. And they keep coming back to this thing and going, no matter what, it's going to come back to Congress to decide this. Congress is going to be the ones who end up having to make this decision. I don't think this is really ever going to be our problem. This is all in Luther v. Borden. They go through all these. And at the end of the day, what they end up saying is that first sentence of Article 4, Section 4 about the Republican form of government is basically never going to be their problem. And they are never going to address it again. And that's it. From that moment forward, from this case on, the Supreme Court never addresses Article 4, Section 4 again. And here's the thing. They don't, from what I can tell, they don't ever address any part of Article 4, Section 4 again from that moment forward. They just kind of ignore it. And it's really bothered me for a very long time because the second part of this talks about protecting states from invasion on application of the legislature or the executive. And it's always really bothered me because it felt like they wrote this off along with that other part because they felt like it was up to Congress. And what I've kind of discovered as I was looking through the rest of Luther today, because Luther, it's really long, and so once I got through, I think that part, I sort of got excited and moved on to something else. But I was looking back through more of this today, and they do start to go back into a discussion, because one of the other things that happened here is that the governor of Rhode Island, when all this went down, instituted martial law. And so they start asking whether an executive is allowed to institute martial law, and they start talking about whether he can do it on application of the legislature, which would be more about that Article 4, Section 4 question. And so I'm starting to notice that this may be kind of the crux of a lot of what we're talking about here. And so I wanted to get through get that whole thing out of my head, and I apologize for doing it so slowly, guys, but it has been sitting in my head all day trying to work its way out, and so I needed to kind of let it out slowly. So I apologize. Charles had said, as a member of the National Guard, it gets complicated as to what status we are in. Yeah, I bet. And determine who is in control. And dual status commander, yeah. So you bring that up. I have been reading... the other case that I have here that's a really big deal starts with a P. Which one is it? It's not the selective draft cases. It's another one that I think is super, super interesting. It's right here somewhere. Perpich. Perpich v. Governor of Minnesota, which is... it's from 1990, and really the only question was about whether or not the governor of Minnesota could say no when the federal government wanted to send the National Guard on a training mission overseas. But they go into this whole discussion and this whole deep dive into kind of the dual mission of the National Guard, and a really big kind of deep explanation of what the National Guard is and how it factors into the Constitution. And it's really fascinating. So, as a member of the National Guard, I'm sure you know a lot of this, but I did not when I started reading this, and I think I first printed this all out, probably back in May or April, back when this all first started, because I really didn't know a lot about it, and I wanted to start answering questions, so I started looking up these cases. And the other great resource that I found, there is a book. I found a digital copy of it that's written by the Army. A lot of you guys who've been here before have heard me talk about this book before. It's in my shared documents under military. It is got too much stuff in this binder, and it's getting unwieldy. But it's the book is written by like the Army Historical Society or something like that. Ah, there it is. Right? Nope, that's not it. It looks like it, though. Oh, I didn't print out the cover, so I don't know the title. The Role of Federal Military Forces, 1789 to 1878, and it's written by, like, the Army Historical Society or something like that. It's a great book. Oh, it's so good, and it's all... I have a PDF of it. It's in 3 volumes. So each one's like a different time period. But it is fascinating. It's in my shared documents in my Linktree. It's and it goes through kind of all of the discussions that were going on in the Constitutional Convention, and kind of talking about exactly as as they're trying to decide, are we going to even have a military, or are we going to rely? Because originally it was under the Confederation, under the Articles of Confederation. Instead of having a central military, we were just going to have a bunch of little ones. Every state was going to have their own military, and if we needed some sort of military support, we were just going to have the states send somebody in. And there's this other case, they just call them, I think, the draft cases, where they first talk about kind of the whether or not it's legal to institute a draft, and that's sort of the root of whether or not that's legal. And they go back to this idea that early on it was legal for the states to institute a draft and under the Articles of Confederation, and therefore that kind of came through and moved forward into the rights of the federal government. One of the things I found really, really fascinating in that case that I just saw yesterday as I was reading it was in the original Pennsylvania Constitution, and I don't know if it's still there now, it said that as part of every citizen's right to life, liberty, and property came a responsibility to protect, to do their fair share to protect that life, liberty, and property. And therefore, when called upon, basically they were allowed to be called upon to put in military service or money or some equivalent thereof, whatever that means, for what would essentially, would commonly call the common defense, because that was part of your right to life, liberty, and property. It came with an obligation to protect everybody's life, liberty, and property, which I thought was a really interesting concept. And that was in the, I want to say it was like the 1770 something Pennsylvania Constitution, and it was cited in that what the heck was the case? The draft case. I have so much stuff here, guys. You want the cite? Is that what you were saying? You just said need. So anyway, yeah, can you tell? I am in it at this point, everybody. Okay, so we're still looking at Luther here. That is my guiding light here that I've been trying to get through today, and part of the reason I went live was to force myself to go through explaining it to you guys at least once, so that I could process my way through it again, because it's been a while since I'd read it. But I also had looked here today, because one of the problems is I read this opinion. I got really, really very upset about this opinion, this Ninth Circuit opinion, because they cited Luther, and they cited it through my favorite book. If you guys have ever heard me talk about this before, America's Constitution, Akhil Amar, is really probably quickly become, over the past few months, my favorite book. I just love this book. And he does go in a little bit about Luther, but really the only part he's talking about when he talks about Luther is the part about the political question, the thing about seating the governors, the thing about seating the members of Congress. That's really all he talks about. In the entire book, he has like a page and a half where he talks about Luther, and it's only really about that issue. He doesn't really talk about the militia part or anything like that. He sort of mentions it in passing, but he really doesn't talk about it. And so I got really mad when I'm reading this Ninth Circuit case, and the guy says, oh, he blows off the, sorry, T-Bone, I got nothing for you. He blows off the plaintiff's argument about Luther, citing this book. And I went and looked at this book, and I'm like, okay, I know Luther. I haven't read every line of it. I may have missed something, which it turned out I had. But I also opened up the page where he talks about Luther, and I'm like, he certainly doesn't say anything like what you're saying there. So I'm starting to get real hot under the collar. I was like, oh, you just read one page and thought you knew enough. Oh, that makes me mad. So anyway, I went back and I was reading Luther, and I was starting to think that I knew more than the judge. And that because the thing about this case is the militia was sent out here, and martial law was installed here, and they did talk about the right of the executive to send in the militia. But it's a state executive, right? It's the governor of Rhode Island sending in the militia in this case. And that's what they talk about. So it's like, how is that applicable? Particularly when we talk about, when we're talking about questions of when, if the governor of the state has specifically requested that they not be sent in. And so I'm getting all hot under the collar. And then I find this line where I was wrong. And I was like, oh, hate it when that happens. So let's see here. Because what they say here is essentially, this is sort of the same thing. It is said that this power in the president is dangerous to liberty and may be abused. But all power may be abused if placed in unworthy hands. It would be difficult to point out basically any better hands to put it in than the president's. So it is true that in this case the militia were not called out by the president, but upon the application of the governor under the charter government, it was sent out by the governor, not the president. But the president recognized him as the executive power of the state and took measures to call out the militia to support his authority if it should be found. And so they're essentially saying, if it had been the president, it would have been fine. The militia is not the United States Armed Forces. That is correct. The militia is the National Guard. And especially from a legal perspective, from the perspective of the Supreme Court, the militia, when they say militia, they mean National Guard, because militia is a term of art in the U.S. Constitution. So all of the states had their own militaries when we started up. And those are now, today, those are the National Guards. And so there was this question when we were starting up about whether the president would be able to access them, whether the federal government would be able to access them or not. And that's been a whole thing that's still kind of ongoing. Can it really be, though, when the president can federalize them? And that has been my question this whole time that I've been trying to answer, and I've been trying to find the answer to, because part of the point and part of what I read in that book written by the Army is that part of the original purpose of keeping those militias in place was to ensure that and this is explicit, this is again, this is in a book by the Army, so this is not, you know, liberal propaganda or anything, to ensure that the states have a kind of bulwark, I don't know what else to call it, against federal overreach. That the states retain their own militaries in case the federal starts to overstep its bounds. But how is that possible if the federal government can federalize those armies? A hedge against a standing army. Very well put. Thank you. Very well put. And so, but how is that possible if the federal government can just take them? And so I have been trying to figure this out. This has been bothering me for quite a while. And I've been trying to find an answer to this. And there does not seem, I have not found an answer yet. The only answer I've been able to find is in Article 4, Section 4, which says, that the federal government shall protect states against invasion and domestic violence. Domestic violence being, you know, violence within their borders, upon application of the legislature or of the executive. Meaning that my read is that they're only allowed to do it when the when the state requests it. But the problem is, if that article has been kind of read out of the Constitution by the courts since this case, then we have this kind of feedback loop. And this is what I'm trying to figure out. I've been trying to figure this out now for 5 months. I've been trying to find an answer to this question. And the big thing I'm trying to figure out is the well-regulated militias were designed to prevent. That is not correct. That's not correct. He said it's to prevent revolts by. I try to not say that word because it'll get me in trouble. But I have another way of saying it. I can't think of it. But no, it is explicitly not correct. It may have been one of the reasons, but it is definitely not. There's enough discussion in the record that of other reasons, a lot of other reasons, a lot of other reasons. So that may have been one of the reasons, but it wasn't the big one. So, okay. But again, let me clarify. There's never one reason. So I don't mean to say that that is not the reason egalitarian. I don't mean to say that at all. There's always a lot of reasons, and that's part of one of the problems. You know, when you look back at history and you look 200 years ago, it's real easy to say this was the reason, this was not the reason. And even knowing full well that I shouldn't do that, I still have a tendency to say that. Sweet Pea, you can look at the comment right before yours. But it is really easy to say, oh, this is the reason they did it, this is the reason they didn't do it. The reality is, there were thousands of people there. Every one of them had their own opinion, just like today. So, yeah. You got some questions. Fire away, Ken Thorpe. And I'm gonna keep babbling. But like I said, I'm sort of, what you're watching here is me kind of working through this, because I've been working through this for a while, and I keep, every time I pick it up and try to work on it, I get frustrated and stick the binder somewhere and don't come back to it for several weeks because it's very frustrating and I can't find the answers. So I wanted to bring it out and kind of talk through it a little bit with you guys and see if I could get to some answers. Black's Law Dictionary, yeah. Black's Law Dictionary is not law, by the way. Black's Law Dictionary is just it's like any other dictionary. I don't know why people seem to think that Black's Law Dictionary is something special. It's I own a copy of Black's Law Dictionary, but I sort of forgot that I owned a copy of it. I usually use the Oxford English Dictionary. I like it better. And you can use any dictionary in court. It's crazy that we have justices on the Supreme Court who say they believe in precedent, but, so, you know, stare decisis is not a rule. It's a policy. it's policy that should be followed because it's how our system kind of holds together, but it's not a rule. Did you know there's 3 kinds of English? There's lots of kinds of English. Okay, I don't know how I can... Oh, I can do this. All right, how about that? Oh, I just figured out that I can... Sorry, guys, give me one moment. Just figured out that I could do something. It does make it, yes, Black's Law Dictionary makes it, can use Urban Dictionary in court. Yeah, if it's the right thing to use. So here's the deal with the dictionary. It depends what I was trying to prove, right? Hey, Nicole. It would depend what I was trying to prove. If I was trying to prove to a court that sometimes people use this particular phrase in this way, then bringing in an Urban Dictionary definition, especially one that had a date on it and showed that it had been around for a few years, might be a good way of proving that. If I wanted to prove that this was the definition, the only definition of something, that's not going to do it. As a matter of fact, I don't think there's really any way to prove that something is the only definition of something, because that's not something, no, that's never true. So, definitions are a funny thing. They're squirmy and sticky. Okay, so got through that. That was an important one, and that was the big thing I found today. But here's the other thing I found. So, where was it? All right. So there's this other case called Martin v. Mott, but I'm not going to get into that now. And I want to see here. They're talking about a particular one of the militia acts, but I'm not going to get into the... Okay. The power given to the president in each case is the same, with the difference only that it cannot be exercised by him unless upon the application of the legislature or the executive of the state. And that is very similar. Right. Now I remember that. So this is part of the problem. Hey, Oregano. This is part of the thing, is that there were a couple of militia acts that all came out sort of in a row. And the first few seem to mirror this Article Section 4 language. No, that's not correct, Ken Thorpe. And a few of them seem to mirror this for a while, and then they stopped. But that doesn't mean that it shouldn't have continued to mirror this. And so I'm not sure why it changed. I've been trying to figure that out. But the first few versions of the law did restrict the president's ability to send out the militia to situations where the legislature or executive requested it. And then they kind of cut that out, and I'm not sure if it just kind of got cut out in an edit or whether it was intentional. But I'm still trying to find an answer to that question, and there's a professor at Georgetown who wrote like a definitive article on this, but didn't get into that question. I've been trying to get a hold of him. He just recently got on TikTok, so I sent him a message, and I was waiting for him to hit me back, and he wasn't hitting me back, and then I realized he posted like 2 videos back in September and hasn't been on since. So, I'm gonna have to wait for him to come back in. Read The Chain, the Dog of War. Excellent book. Okay. Oh, okay. All right. So when a court responds to you, their words are defined in blacks. That's just not true. The words, I don't even know where to start with that, Kent Thorpe, but that's just not correct. Words are, yeah, no. Okay. Black's Law Dictionary is kind of worthless. What was the outcome of the case we tried to listen to yesterday? It's not correct, Kent Thorpe. I don't know what to tell you. So the outcome was I keep going back and looking, and everything is sealed, which is why we couldn't get in. I keep going in and looking for the stuff, and everything is sealed. Yeah, Lisa Burden. Yeah, no lawyer looks at Black's Law Dictionary. So I'm not sure what happened in that hearing, but I just defined to everybody on here how little I know. All right, well, my 12 years as an attorney are all right. I don't know what to tell you, Kent. Why would it be sealed? I don't know. But we went in. I went in and tried to listen to the hearing, and the hearing was closed, and so I don't know. I don't know what the deal was. I got excited, but everything, like, all there are like a bunch of filings that have happened since that day, and they're all sealed. So something happened in that hearing. They said something that was classified or something like that, and now everything's sealed. And they said, I think the transcript of the hearing is sealed for a certain number of days until the parties have had a chance to go through and redact it. So we will be able to see it, but it could take I think often it's like 30 days that they have to go through and redact it before they will release them publicly. So we're not going to know. So it was the case, the Chicago Headline Club, the case about the First Amendment in Chicago, which I honestly think is going to be one of the more important cases that we end up talking about with all this. By the way, if anybody's curious, I took club soda and added some apple cider to it, which is why I'm drinking brown club soda, in case that looks gross. I just realized as I was drinking it, wow, that looks probably pretty nasty. But I got really, really good apple cider a couple days ago, so I mixed it in with my club soda, and it tastes like apple cider soda, so it's very tasty. Would a judge have to order it to be sealed? The judge would have to order it to be sealed, but the government probably requested. Oh, thank you very much, Milton. The judge probably requested it, or I'm sorry, the government probably requested it. My guess is there probably, guys, there were almost certainly there was something in there that was probably not allowed to be public. It probably wasn't even that exciting. You know what I mean? Like, if we knew what it was, it probably wouldn't be anything that exciting. They probably were, somebody may have given out their home address or something, and during the hearing, and it could have been something simple like that. It's easy to get excited and be like, what happened? Even I did it until just a second ago when I thought it through and was like, okay, thank you very much, guys. It may not have been anything as exciting, but for whatever reason, now everything is getting sealed. So, and I can't really think of why that is, but that doesn't necessarily mean it's something super interesting, It could be. I was a little bit more annoyed when they started sealing documents based on the argument. I did actually see some stuff getting sealed maybe 5 months ago or so, based on the argument that they were trying to avoid certain conversations within the government, and I was like basically they were trying to stop people from talking about this subject at all in the press, and I was like, that's no, that's not okay, but whatever. Are there time, place, and manner restrictions to freedom of the press the same way there is speech? Maybe. I'm trying to think. Probably not exactly the same. There are kind of, they're allowed, I will tell you that in the temporary restraining order from the judge in this case, the judge said that the officers were allowed to tell the journalists to move, over there, as long as the place they told them to move to would not restrict their ability to report. So they were so technically that's a time, place, and manner restriction. They were allowed to say, "Hey, could you go on, on that corner instead of this corner?" As long as they could still, it wasn't blocking. They weren't trying to say, "We don't want you to see what's happening here." It was more, "Could you, we're trying to drive a car through here or something, and you're sort of in the way." Like that was allowed, but they weren't allowed to restrict their ability to report. So, time, place, and manner restrictions around publishing. I can't think of any. Well, see, here I am. No, see, this is the problem. Is one thing about the law is there's never 100%. Nothing's ever 100%. But as a general rule, I mean, they're allowed to say, certain. Classified stuff maybe isn't allowed to be published sometimes. I don't even know if they're allowed. I don't know. Yeah, I'm trying to think. So one of the things that I know is, sometimes bigger journalism organizations will be more willing to comply because they know that if they start publishing classified information all the time, they're not going to be given access. So, access to active crime scenes. So yeah, that's a good, yeah. So yeah, there's probably there are some restrictions, but they're going to be they're going to go through some sort of a reasonability standard. They're going to go through some sort of a balancing the general idea that we want people having access to stuff against when we are willing to restrict that access for some reason. That's always going to be sort of the two things we're going to try to balance. And somebody asked, is spitting assault? It's depend. So the problem with assault is that there are a bunch of different definitions of assault. There are some definitions that the answer is yes, and I'd probably have to think whether actually there are any definitions where the answer is no. Actually, there are a lot of definitions of assault that are not actually touching, but rather threatening to touch is assault. I think that's common law assault. So, yeah. What's your thoughts on rolling coal as a battery? I don't know. Could you... I don't know. Interference is going to be a question both ways. Oh, yeah. Could you give me... I'm not sure what... Rolling coal as a battery. Explain what that means. Rolling coal as a battery. I am generally fascinated by any kind of interesting battery, any kind of kinetic energy uses. So, yeah, but I don't know what rolling coal is. That's good. All right. Calais. Rolling coal is a diesel exhaust. Oh God. I don't. I mean, I don't understand why anybody would do that, but. Calais. I definitely don't think it's the what I didn't hear what a lot of people seem to hear. However, one of the things about a Supreme Court argument is that the people who've already made up their minds don't talk. Um, so, assuming that if Thomas doesn't say a word for 2 hours, that doesn't mean that Thomas is not a vote on one side, and maybe a very persuasive argument in chambers. So who knows what is going on in Thomas's head if Thomas never says a word? If the only people you hear speak is, or if the only people you hear speak are on one side, and it's only 2 to 3 people, it's not a great sign. So I don't know. I didn't hear it's so that is part of the problem, is that a lot of the times I will walk out of a Supreme Court argument thinking I know what happened, when in reality what I heard. Calais is the Voting Rights Act case. And the problem is that sometimes I'll walk out thinking I know what's going on, when in reality all I heard were the people who are who want to argue with one of the lawyers, but not necessarily the people who are going to win. And so that's the problem, is that sometimes I'll think I know what happened, and I'll be wrong for that reason. That said, I certainly did not hear. I didn't hear anything that made me super concerned. But I'm always worried that some of these people who've been doing this for years and years, are better at reading a Supreme Court argument than I am. And are better at watching for that one little question that is far more telling than the hour and a half of questions that I paid attention to. So that is my only concern, if that makes any sense. But I certainly didn't walk out of there. I walked out of there, and then I read all these newspaper articles that were like, the sky is falling. And I was like, did everybody else listen to the same questions I did? Because I didn't hear any questions that sounded like that. But I always wonder whether they heard one question that was super telling if you knew what to listen for, and I just didn't hear it. So I never know. I'm always worried that I always like to, I talk to Attorney Di all the time about, I think her brilliance is her ability to see the trees. Is that backwards? To see whatever. That I will get lost and miss the forest because I get stuck looking at a couple of trees. And she is so good at just catching every detail. I am so impressed with her ability to. She's amazing anyway. So we've been talking about Luther v. Borden, which is a 1849 case about that talked, among other things, about the use of militias in the states. But anyway, so that's I have a tendency to hear one thing, and my brain will go off for a second, like, oh, wait, what was it? And then all of a sudden, it's been 2 minutes, and I'm like, wait, what were they talking about? So, that's just sort of who I am. Let me see here. A lot of people, one of the things that I try to that I've tried to do, the Supreme Court they've done a lot of stuff that sucked. for years. They've always been slow to respond. They've always been, the molasses of the government. But we need a branch that moves really slowly when the other branches move too fast. And so, as frustrating as they can be, in a time like this, when every other branch is trying to push, change, they may not be there to always do what we want, but moving very, very slowly might be more useful than we realize. But it's also very frustrating at times. But you go back and look at them in the 1920s, in the 1930s, in the 1940s, 50s, 60s, and there's always cases where you think, oh, this is the worst case ever. And then you go back and you're like, oh, no, it is not. No, it is not. It's just kind of what they do. And what they've always done is make unpopular decisions that everyone hates. That's just sort of, oh my gosh, guys, I have read some cases that are like, how did you do that? How on earth did you do that? And then you look at it and it's like, this is like one of the most famous Supreme Court justices of all time who's supposed to be, how did you write that? What was I just reading the other day? It was like, oh gosh, what, it was from like 1912, and it was, if I can think of his name right now, it's like the judge, the one of the ones that we think of as Oliver Wendell Holmes. And it was just this horrible decision. And I've loved so many things he's done, but it was just so awful. And I was like, oh yeah, right. It's still the Supreme Court. Sometimes they just suck. So anyway, I'm not totally, I'm just, sometimes you got to put them into context of them sucking. Yeah, and I know their emergency docket right now, they're doing some stuff that, yeah. But yeah. All right. But I think I forget why I was headed in that direction. I don't know. Okay, folks. All right. So what I really wanted to do today was to get through this a little bit. Oh, there was one last thing that I wanted to get through here, which was I think I did that. Okay, so we had the different militia clauses, which is something that I'm going to need to get back to, and I appreciate that you guys came with me on this, because I've been trying to remember all of this stuff that I've been looking at for months and trying to get back into it. Let's see here. And then there's a dissent, which is kind of a mess. I'm kind of wondering whether here they're getting into here about the officers engaged in military service who can lawfully arrest people, and whether or not that's possible, which is really a big question. This is before the Posse Comitatus Act. Without the power to do this, martial law and the military array of the government would be mere parade, and rather encourage attack rather than repel it. No more force, however, can be used than is necessary to accomplish the object. And if the power is exercised for the purpose of oppression, or any injury willfully done to person or property, the person by whom or by whose order it is committed would undoubtedly be answerable. Okay, but what does answerable mean? So, let's see here. We forbear to remark upon the case referred to in the argument. The commissions anciently issued by the kings of England to commissioners to proceed against certain descriptions against law martial. So now we're going back into Charles the First and all this garbage. And then they're just going to talk about whether or not it was okay for the court to allow. So this is Luther v. Borden, and the reason that I'm just talking about this today is that it was cited by this judge in their decision to allow the deployment of, or whether it's deployment or not, I'm still not sure, in Portland, Oregon. And mosquito. How are the mosquitoes still alive? It's freezing out. And so I've been trying to figure out whether they did that properly or not. I am pretty sure that the judge did not actually read the case. Ha! Got him. Did not actually read the case before he cited it. But I still don't think he's necessarily entirely wrong. Although he might be a little bit wrong. So I need to go back and read Martin v. Mott as well, I think. Oh my God, guys. So much reading. So much reading. My brain gets tired. All right. So that is where I am right now. I wanted to walk you guys through this, and I needed to walk you through this, and so I stole your brains for a little bit so that I could do that. I really appreciate it. I am going to go grab some dinner because I haven't eaten. I think I am probably taking tomorrow off of the morning report because A, there's not a ton happening, and B, I really do want to focus on reading this for a day or two. A love for academic writing. Yeah, me too. And I want to focus on answerable but limited in presidential immunity, and so that's part of the problem is with presidential immunity, who is answerable and how are they answerable? And that was part of the question in the Newsom v. Trump response. That was part of during the oral arguments, or the oral arguments. That was part of what the judge said, is that if the government attorney said that essentially the only person responsible at the end of the day was the president, and it was only a criminal charge. And the judge said, well, if the only person responsible is the president, and the only way of holding him accountable is a criminal charge, and the president has presidential criminal immunity, then no one is accountable, and that's not an acceptable answer. And so that was, I think, what may have sunk that their chances of winning that case. It was a pretty interesting moment. He just kind of kept pushing and pushing and pushing that attorney until finally the attorney just gave him an answer that short-circuited. All right, guys. I will talk to you all later. Thank you very much. And yeah, like I said, I think I'm taking tomorrow morning off so that I can do some more research. I'm going to try to put something together that's a little bit bigger and it's going to take me a few days. But particularly with a lot of these courts taking a break, there's not a lot happening. So I will talk to you all.